My name is Jamie LaValle. I'm a Muskeg Lake Cree Nation citizen. I'm also an assistant professor here at the College of Law, and I am pleased to welcome you to the McKercher LLP lecture series at the College of Law, a panel discussion entitled Law, Advocacy, and Public Perspectives, the Impacts of the Boushie Case. As we gather here today, we acknowledge we are in Treaty 6 territory and homeland of the Métis. We pay our respect to the First Nations and Métis ancestors of this place and reaffirm our relationship with one another. I would like to begin by thanking McKercher LLP for sponsoring our lecture series for the last 4 years, allowing the college to continue to present a wide range of informative, educational, and engaging speakers to the law school community. Over the next hour, we will hear from each speaker, followed by an audience Q&A. I do want to have some housekeeping right at this moment. One is, of course, check to make sure your cell phones are at least muted. The other one is that we have until 1 p.m., so this is literally an hour, because classes start for most of our students, and there are also classes inside of the overflow rooms. So if those in the overflow rooms want to talk to the panelists, then please come to room 150 afterwards, because we do not have a Q&A capabilities in those rooms. But we need to note that we are a college, and as such, we have only until 1:25 in this room, totally, before the conversations need to close down or move out or go to email, because we have a class here at 1:30. Okay. So our speakers today are Eleanor Sunchild, who is a Cree lawyer from the Thunderchild First Nation in Saskatchewan. She received her Bachelor of Laws from the University of Alberta in 1998 and has been a practicing lawyer for 12 years. She has worked extensively in the Aboriginal community in all areas of law and is also a seasoned criminal lawyer, but is concentrating her practice on residential school law. She has a particular interest in human rights and the impact of residential school on Native peoples, and she is sincerely interested in collecting the stories of the survivors, as these claims illustrate the strength and resilience of Indian people. And then Doug Cuthand is an independent film producer, director, writer, and journalist whose career has spanned over 20 years. His work frequently has been recognized and honored by the media industry. Weekly columns in the Saskatoon Star-Phoenix and Regina Leader-Post and features in the Winnipeg Free Press have made Mr. Cuthand a respected voice for the Aboriginal community. A collection of his newspaper writing was published in 2005 as Tapway. His film and videos have been featured by the National Film Board and aired on the CBC and numerous local and independent television stations. They have also won awards at the American Indian Film Festival, the Geminis, the Saskatchewan Motion Picture Association Awards, and the Columbus International Film and Video Festival. He was awarded the Native American Journalists Association Award in 2003 for Best Column. And then in the middle we have Professor Estair Van Wagner, who researches and teaches in the areas of land use, planning, natural resource, and property law, and is co-director of Osgoode's Environmental Justice and Sustainability Clinic. Professor Van Wagner joined Osgoode from the Victoria University of Wellington Faculty of Law, where she taught property, natural resource, and resource management law. She completed her doctoral work, which was a qualitative empirical study on property and land use in Ontario at Osgoode Hall Law School in 2017. Her doctoral studies were supported by a Social Science and Humanities Research Council of Canada, otherwise known as SSHRC for everyone else, graduate scholarship, and the Mary Jane Mossman Feminist Legal Studies Scholarship. So to the panelists I've introduced, and now what we'll be doing is Eleanor will speak for about first for approximately 20 minutes, then Doug for about 15, and then Professor Van Wagner for about 10, which we're hoping will leave a few minutes at least for a Q&A, which when we do go to the Q&A though, have one question, not a two-part question, okay? Just so that way everyone, at least if we can have at least maybe 2 or 3 questions from the crowd. So thank you.
Good afternoon, everybody. My name is Eleanor Sunchild. I'm from Thunderchild First Nation. I live in the Battlefords. I'd like to acknowledge Alvin Baptiste, who's here. This is Colton's uncle. Alvin, could you stand? I always bring one of the family with me. I try to bring one of them because this is our journey. We've been on this journey together, and it provides me strength and support if one of them is here. This is Colton. His nickname was Coco. And there's some pictures of him with his family. And as I'm speaking, I'll show you some photos from the past few years. I will be speaking today about the Gerald Stanley trial, the killing of Colton Bushi. There's no question that Gerald Stanley killed Colton Bushi. The family was left with many questions regarding the trial after all of the evidence was presented. I was there, my co-presenter Doug Cuthand was there for the majority of the trial. This has been called the trial of the decade. Some have called it the trial of the century. And for certain, the impact of this trial will be felt for many years to come. My comments are geared towards the trial process and the backstory, what happened after Colton was killed, the story of the family throughout this entire process since he was killed on August 9th, 2016, so that people are aware of what injustices the family speak about in this journey. There's a picture of Colton. This is a well-known photo that's been used in the media. Colton was a 22-year-old Cree man from the Red Pheasant First Nation. He was, by all accounts, a very kind person. He liked to help people. He was a traditional helper. That's what he was training to do. It's called an Osgoode. And he would cut firewood. He would assist in ceremonies, wakes, funerals, all kinds of ceremonies he would assist. He liked to work, and he liked to help people. He was very close to his mother, Debbie Baptiste. He was her baby. And he was close to his siblings. He was also close to his uncle Alvin. He had taken safety ticket training and was looking for a camp job or a job as a firefighter. He had recently started dating Kiora Wetney, whose SUV they were driving in that day. He knew the others in the SUV too, but he was mainly with his family most of the time. So when they picked him up on that day, he did take a drive with them to the Saskatchewan River because it was his girlfriend's vehicle. And even though this should not matter, Colton Bushi had no criminal record. I will sum up what the evidence that was presented at the trial that's relevant here. In the afternoon of August 9th, 2016, 5 young Indigenous people pulled up to Gerald Stanley's farm after an afternoon of swimming. They did have a flat tire. Their vehicle was riding on a rim. Once they pulled up, one of the young men, exited the vehicle. It wasn't Colton, and he jumped on a quad that was sitting in Gerald Stanley's yard. When someone started to yell, the one who jumped on the quad immediately jumped off and ran back into the vehicle when they attempted to drive away. Sheldon Stanley, the son of Gerald Stanley, ran to the vehicle and smashed the windshield. Unable to see, the driver drove into another vehicle. The 2 Indigenous men, not Colton, jumped out of the vehicle to run away. The 2 women and Colton Bushi remained in the vehicle. And at the time, Colton was sleeping. Shots were fired at the Indigenous young man as they ran away. Colton jumped into the driver's seat, and at that point, he was shot in the back of the head. The gun used was a Tokarev T-33, a restricted firearm. 911 was called. The 2 girls ran away. The Stanley family went inside after Bushi was killed and waited for the police to arrive. On August 10th, 2016, a day after the death, Alvin phoned me, And he told me that his nephew had been shot, and the RCMP were saying that it was a theft-related investigation instead of the killing of his nephew. And that's how I became involved. Based on the initial RCMP press release, it did not seem that the RCMP were investigating the killing with the full force and vigor of a murder. We were right. For that very evening that Colton was killed, the RCMP barged into Debbie Baptiste's trailer, that's Colton's mom, and asked her something to the words, "Who is Colton Bushi to you?" And when she answered, "My son," she was callously told, "Oh, he's deceased." She fell on the floor crying. The RCMP then proceeded to search her house. She told them that she was waiting for Colton, that his dinner was sitting in the microwave, that he couldn't be dead. So they went and they checked the microwave to see if his dinner indeed was in there, and it was. They then smelled her breath and asked her if she had been drinking. They exited immediately and left Debbie like that, devastated, without support. The family, still, they hoped for justice. The family hoped for justice even though the Indigenous witnesses who were in the SUV with Colton were arrested and questioned following his death. The family hoped for justice even though a day after his death, the RCMP press release stated that 3 of the young people were taken into custody at the scene due to a theft-related investigation. This in itself provided just enough information for the general public to make up their minds where they stood in this case. They hoped for justice when the following day the Federation of Sovereign Indian Nations issued their own press release stating that an Indigenous man was killed by a non-Indigenous farmer. They hoped for justice when the SUV that Colton was killed in was left in the rain with the doors open. Colton was killed on the late afternoon of August 9th, 2016, and the warrant was issued sometime later in the day of August 10th, and the RCMP went to the property to process the scene the morning of August 11th, even though it had been raining heavily, and presumably much of the evidence was washed away. They hoped for justice even when late Colton's body was left on the ground during the time they waited for a warrant in the rain. There's a picture of the SUV. They hoped for justice when the blood expert was given photographs to analyze and was not personally brought to the crime scene to provide the basis for her expert opinion. They hoped for justice at the first court appearance of Gerald Stanley when there was excessive police presence and police on top of the liquor store across the street from the courthouse and on the movie theater on the other side of the street. They hoped for justice when the RCMP officers stood with their backs to Gerald Stanley's family, seemingly protecting them at the courthouse and escorted the family in and out of the courthouse as well. They hoped for justice when the family of Gerald Stanley, and there's camera footage of this, when they were escorted to the RCMP detachment for lunch between the first court appearance and the bail hearing. In my 20 years of defense work, I have never seen an accused family taken to the RCMP detachment for lunch. The Boushie's and Baptiste family were not taken to the RCMP detachment for lunch. Yet, the family remained hopeful that justice would be served. The family hoped for justice as they were met at the bail hearing that afternoon with the police in the elementary school across from the Court of Queen's Bench and numerous RCMP officers in and outside of the courthouse. There's the courthouse. The family hoped for justice as they were met with the drummers that they heard outside the Court of Queen's Bench and the number of supporters who were there with signs, not protesters, supporters. And they were singing songs of sacred songs of love and support for the family during that mail hearing. And despite those drummers asked to be quiet, the family still had hope. Gerald Stanley, charged with second-degree murder, was released on $10,000 cash bail. The family hoped that they could seek justice on their own when they petitioned for an independent investigation and an extra-provincial prosecution of the case. And even though this request was denied by the Saskatchewan government, they retained their hope. The family hoped for justice even though the whole city block was petitioned off by an excessive police presence during the preliminary inquiry. They remained hopeful even though on the first day of the trial, each and every Indigenous-looking prospective juror was challenged and an all-white jury was formed. And why is that important? Well, I've seen it happen. I've seen how an Indigenous person or two or three, as should have been, given the demographic of our area, how an Indigenous person can change the dynamic of a group, especially if there are stereotypes or racism involved. An Indigenous person will have a different viewpoint based on life experience and could challenge racist ideas such as all Indians are drunks, all Indians are thieves, Indians get everything for free, much of the rhetoric that we heard in social media surrounding the trial of Gerald Stanley. The family remained hopeful, even though Colton was vilified on social media, called a drunken Indian, a thieving Indian, a gangster, and he had no gang affiliation at all. He was blamed for being on that farm, and many expressed the belief that he deserved to die for being there. There were comments like, shoot, shovel, shut up. Comments like, all Gerald Stanley did wrong was leave witnesses. The barrage of hate continues, and it continues to this day. The family remained hopeful for justice even when Gerald Stanley stated that the thing just went off. The gun evidence at times was confusing, even though there was more questions that could have been asked. They hoped that the evidence presented was enough to obtain a conviction, at least of manslaughter. That was the hope, and it would have been enough. They continued on to hold on to hope, even though self-defense was not put forth. Many terms were used, such as home invasion, your yard is your castle. They hoped that the system would be just, even though there was much evidence about the witnesses, the Indigenous witnesses' level of alcohol. Right until the very end, even in the moments just before the verdict was delivered, when the judge commented that everything should remain with the same civility that had been shown throughout the trial, did the family retain hope. Even after the not guilty verdict, during those heavy moments of grief and despair and disbelief, in the days that followed during the Ottawa trips and the meetings with the politicians, the ministers, senators, media, and advocacy groups, the family hoped for an appeal. They held on to that faint hope that our justice system was fair and inclusive. They hoped for justice, and then 30 days after the verdict, the Saskatchewan government held a press conference. Again, another first I'm seeing a press conference not to appeal. Yet they held on to hope because Colton was Debbie's son, Alvin's nephew, Jade, Jace's, Satin and William's brother. The family used that hope that they would be able to find justice for their loved one, Colton, as they began traveling across this continent to seek that justice. They went to the United Nations to request that the UN Special Rapporteur on the Rights of Indigenous Peoples come to Canada and to our province of Saskatchewan to investigate the apparent racism in our justice system, to advocate for a royal commission into the systemic discrimination in our justice system, to make sure that no more families were treated in such an offensive way as this family was. They hoped, even though the justice system is failing Indigenous people, and historically, it is a system that does assist even historically, it's a system that does not assist the people it's meant to include. For example, many people are aware that the RCMP were often used to remove children from their family homes and they take them to Indian residential schools. They hoped that the days of the Starlight Tours were over and that our people would be treated fairly by our justice system. The family retains hope that they and others will continue to advocate for Colton Bushi, for Jonathan Styries, for Tina Fontaine, for Barbara Kenter, for Neil Stonechild, for Nadine Machiskanik, for Brendan Ahanekyu, for Helen Betty Osborne, for Pamela George, for Leo Lachance, and so many others who face similar injustice, so that the justice system does not continue to exclude Indigenous peoples any longer. The family will continue to advocate for a royal commission or a public inquiry to illustrate how our justice system failed Colton Bushi and many more people like him. The family will continue to ensure that concrete changes are made to the justice system that recognize the treaty rights of Indigenous people to live unmolested, to live in peace and friendship, to share the land as our treaty promises. The family witnessed hope during the rallies and the worldwide support that was shown since the verdict. The family is hopeful, and I am hopeful that this case, the trial of Gerald Stanley and the killing of Colton Bushi, has brought light to the racism and the blatant discrimination that this family has faced. And even though this journey is hard, the anger and grief is real. It's so real that we hope that this story is told over and over so that no other Indigenous people, or any people for that matter, have to face what this family has faced as they sought justice for Colton. They will continue to fight, to advocate, to speak out, because we hope that you or I never have to bury our child because he went into the wrong yard to ask for help. That we never have to say to another grieving mother, Agamemut, don't give up. We will find justice for your son. We do this for love, and we hope that you, in your pursuit of justice, will do the same. Thank you.
Do you think you can take this now, Doug?
Pardon?
I was like, it's your turn now.
Okay. Yeah, I'm just waiting for the applause to die down. Yeah, I'm from the Little Pine First Nation, and it's in the Battlefords, a short distance away from the Red Pheasant First Nation, and my family has relatives on Red Pheasant as well. So we're familiar with the reserve and with the people there. The trial for the Gerald Stanley for the killing of Colton Bushi was a defining event for this province. It brought the issue of racism into stark reality, and in the end, the province of Saskatchewan was the one on trial. Stanley may have walked free, but the province was found guilty. What the hell was that? Scary. Now, the trial and the events leading up to it showed that Canada and the world, as Saskatchewan, is seriously divided along racial lines. Now, I attended the trial as a member of the media, and I saw how the trial was conducted, and two important factors stood out for me. Now, I don't have a legal mind, but I did take sociology, so I have a mind and look at society and see what's out there and compare it with ourselves. It's been an interesting perspective as a journalist. So this trial was conducted as a settler perspective. There's no doubt about it. The jury was all white. The judge, the clerk, the Crown, the defense, they were all white as well. The accused was white. And the Indigenous witnesses were treated as if they were the ones on trial. The whole thing was just flipped upside down. It was really weird to watch. and issues that were sensitive to our culture were ignored. And this is not unusual in the courts of law or inquests, but still, it stands out to us, it just seems to be an ongoing fact, and I hope that this can be changed in the future, because we have certain beliefs that are not acknowledged by the courts. For example, when an individual dies, their spirit begins a journey to the next life. And you can't impede that journey. You have to do everything you can to bring them on. You can't mourn in the extreme. You can't, carry on. You even when we bury a person, we walk away from the grave and don't look back. The idea is that that person must go to the next life. So we don't repeat the word, the person's name, and we give away all their possessions. And so when you go to a trial like this, and the name of the deceased is heard over and over and over again, and brought up, and pictures are shown of the victim at the body and stuff like this, it just tears us apart. People will not go to a trial for that reason. I spoke to Alvin about this, and he said that his mother would not go to the trial, listen to her grandson have his name repeated over and over again, because it was a sacrilege. It really was. And this came up a few times in the witnesses as well. Eric Meachance was one of the young men who was there that day, and he was asked to identify the rifle that was in their possession. And they showed him a picture, but the rifle was right beside the body of the deceased. And that was a taboo. You're not supposed to show a picture of a dead person like that. And he quite rightly broke down, and they had to stop the court proceedings for a while so he could pull himself back together again. But that was another example was Belinda Jackson. She was one of the women who was there, and the Crown asked her, not the Crown, pardon me, the prosecutor or the defense. Get this straight. The defense asked her to show how Stanley held the gun when he shot the deceased. Well, for heaven's sakes, she couldn't do that. That was it was showing a picture of how, or it was mimicking what had happened when her friend was killed, and that can't be done either. That was, and she said she couldn't do it. She said she'd rather not. I think that was her words exactly. And then the defense concluded as a result that, well, obviously you don't remember. And the Crown prosecutor just sat there and didn't do anything, because he didn't know either. See, our cultural and our traditions were just being sort of thrown under the bus all throughout this trial. Now, these incidents happen in courts in Saskatchewan every day. And very often valuable evidence is left out because of our people refuse to give this kind of evidence. And there was other factor that came in. As I mentioned, the deceased's name was called over and over. One of the things that, on one hand, it's a bit humorous, but on the other hand, it was very real. And it took me years to discover this, that white people fear Indians. I didn't realize this. I grew up just being a kid and being an adult, and it wasn't until I started work with the FSIN, and I was given a job as a health coordinator, and we had I was having a problem to get the health staff to go out. This is the white health staff from Health Canada, to get them to go out to 10 meetings on a reserve. And then one of the Indigenous staff members pointed out to me that they were afraid of Indians. And that came as a complete surprise. But one time, this is a true story. One time we had a team of deputy ministers and whatnot from Health Canada came out to Saskatchewan here, and they were doing a fact-finding mission. They went up to a northern community, and they landed at the airstrip, and they were waiting for their ride, and then they heard gunfire in the community. And they immediately, they panicked. But it's our custom that when a couple gets married and they step out of the church, the men will fire their rifles off in the air as a part of the celebration. So obviously there was a wedding in town. The men fired off their rifles, and the health officials panicked, got back on the plane, and left. And Meanwhile, the chief and councillor is sitting in the band office waiting for this meeting. So and this sort of thing happens more often than you should think, you know. And the defense did that. They played on the jury's fears. They fed them a steady diet of fear by painting a picture of an out-of-control group of young people, speeding around in a loud car, drinking and looking for trouble. And I recall that the Baptiste family sat in court and they held up a feather. It's a symbol of truth in our culture. And the jury complained to the sheriff that it was bothering them. Again, I don't know what they thought. They were being hexed or something. I really don't know. It was just ridiculous. But it was a symbol of truth for us, and showing a symbol of truth in a courtroom is a natural thing. Anyway, but the real manifestation of the fear occurred was when the verdict was given. It was unreal. First of all, members of the Baptiste family cried out because they were hurt. They were deeply hurt. It was something that they just couldn't imagine. We thought there was going to be a manslaughter conviction. Even the guys in the media room thought, you know, they probably won't go for a first degree, but they'll go for a manslaughter. So this came as a complete surprise. And what happened was just outright panic. Gerald Stanley just ran for the door and was hustled out by sheriffs. He jumped in a pickup truck, and you just saw the taillights disappearing down the highway. And meanwhile, the jury cleared out of the room as fast as they could. It was just, and it was just a panic. And yet the family were not out to get them. There was no aggressive action taken by anybody. They were deeply hurt, and they were suffering. And yet chaos reigned supreme. And that's what you see in the news, is how quickly the place, you know, it gives you the impression that they were under threat. The impression was given that there was the jury was deeply, well, they were scared, but they didn't need to be. And what it was kind of interesting was that among my group, well, there was a guy I know who was a farm boy, and he was one of the media, he was a sound technician. And he would go out in the evening, you know, he'd leave in the afternoon and go with the farmers. And, well, our people would go down to the tribal council office and smudge with sweetgrass and debrief and talk about it, maybe say some prayers. The farmers went straight to the liquor store, straight to their hotel rooms, and partied long into the night. And they did this every night the trial was on. And this friend of ours, who was planted as a spy, well, he was. That was a serious comment. We put him in, but he went out with these guys, and he wouldn't tell me what they were saying about us, because he was just he was appalled, actually. But it became apparent that we're facing racial hatred in this province, right on par with southern United States or South Africa. There's no doubt in my mind about that at all. And the other thing is, what many people don't realize is that this was a national movement that was taking place. There was a strong reaction and support for the Baptiste family across Indian country. People said prayers, they conducted ceremonies, sweat lodge ceremonies were held. It was all done in support of the Baptiste family to get justice. And you have to, here again, our culture has to come out, because we can't call for revenge when we pray to the Creator. You have to call for justice. You can't call for harm to come to the Stanley family. You can't ask the Creator for that. That's wrong. So it's not our place to ask the Creator to bring harm to others. Our prayers must be positive, and they must call for justice and fairness, as well as strength for the relatives of the deceased. So that was what it was all about. There was the Indian country was rallying around this family, giving them support and love. It wasn't a negative thing at all. And we believe there are two kinds of justice. And there's a justice that you students are learning today. It's the justice of the land. It's written by men and women in Parliament. But we believe in a second kind of justice as well, and that's natural justice. And if you come from India, it's called karma. Our elders tell us that you got to be patient because what goes around comes around. Hatred and fear cannot correct what has happened. So, in my line of work, I've been around for years. I've met many people, and I got many friends in high and low places. And well, so do you, Dawn. And one guy who was a friend of mine, he was a drug addict, and he spent a lot of time in prison. And he told me of a man who was having nightmares and screaming in jail at night. And so one day he asked him, he said, "What's wrong? Why are you doing this?" And he said, "It's because he's in jail for killing someone." He said, and when he went to sleep, he would have dreams and about the man he killed. And he had genuine remorse, but there was nothing he could do. And while someday he could leave the institution, his time in prison would last for the rest of his life. Now, I don't know if this is the case or not, but Gerald Stanley must have his moments when he wishes he could turn back the clock and the events of August 9th, 2016. That will haunt him for the rest of his life. He will lie awake at 3 a.m. in the morning, and he will be haunted by it. It's called the dark night of the soul. Now, to conclude, we have a Hutterite colony close to our reserve, and we have good relations with our neighbors. Now, a friend of mine told me that a friend from the colony was supposed to drop by to his place on Saturday, but the verdict came down Friday, and he failed to show up. Finally, on Monday, my friend went to look him up, and he said, asked him what was wrong, why didn't he show up? And his Hutterite friend told him that he didn't think it was a good time to go to the reserve. To which my friend replied, "You're not a white man, you're a Hutterite." And you see, race is a state of mind. The Hutterites are our friends, and we both have a strong sense of our community, and we're both tied to the land. So we get along with our settler neighbors, but there are many others who live in a bubble and refuse to interact with us. There are individuals who lash out on the social media, dissing Indians, even though they don't know us and avoid learning more. Over the years, I've noticed that those who hate us the most know us the least. They are products of fear and ignorance, two emotions that form a potent mix that lead to racism. And this was on full display in the Battleford courthouse a year ago. Thank you.
I just want to say thank you to the organizers for inviting me here and welcoming me to Treaty 6 territory, and my esteemed fellow panelists. I feel a bit humble about what I can offer there, and I hope you all don't hold it against me too much that I am here visiting from Toronto. I'll do my best to overcome that. My work in relation to this case has been with a larger group that we call ourselves Project Facta, and we gathered together under the leadership of one of my colleagues, Professor Signa Domshanks, who's well known to many here at Saskatchewan, to figure out whether we could serve a purpose as scholars and as lawyers similar to a kind of amicus curiae, a friend of the court. We thought of this role in terms of how we could help with an appeal, because we fully expected there to be an appeal. We now know that there was no appeal, but we've continued our work thinking that this case is so important, as we've already heard, that we need detailed legal analysis of specific aspects of the case that we found particularly troubling or compelling. We were able to order the transcript with the support of the Dean of Windsor Law, which now allows others to access it at a lower cost. And we were the first to try and piece things together from the reading of that transcript. And that work continues to this day in a range of areas. But as you've heard, I am a property lawyer, so what I will talk about today is really quite specific to that. I am not in any way, shape, or form a criminal lawyer, so I can't answer any questions about that work, though my colleagues are working on criminal law aspects of the case. Really, what we're interested in is how property and conceptions of property and ideas about specifically trespass entered into this case in very problematic ways. And we need to figure out how we can avoid that happening in future cases. This case raised foundational concerns about those conceptions of property and the way they inform our relationships as Indigenous peoples and settler peoples, and our relationships with the lands on which we live and work. In particular, we have drawn attention to how the youth on the Stanley farm that day were labeled trespassers, both within the courtroom and outside. It seems to be presumed that this label is somehow helpful in explaining the outcome, both the outcome on that day and in the trial. Indeed, one of the central legal responses to the death of Colton Bushi and the trial has been in the area of trespass law. Therefore, it's essential that we understand what we're actually talking about when we talk about trespass and the role it might play in criminal law. Trespass is a concept in both criminal and civil law in Canada, and the essence of trespass is really about the protection of possession and control over private land, as well as the privacy of the possessor. In civil law, trespass is a tort which owners of private land can use to enforce their right to exclude others from their land. In criminal law, trespass can be an offense. It can also be the basis of a defense. As an offense, it's largely dealt with under provincial quasi-criminal statutes, such as Saskatchewan's Trespass to Property Act, which provides for arrest powers and fines for entry onto land without consent, where notice is given or land is enclosed. The meaning of trespass is quite similar in civil and criminal law, but the treatment of trespass and associated remedies is inconsistent, we have argued. The civil law provides for monetary damages or injunctions through suits brought in tort. Quasi-criminal provincial trespass statutes establish the offenses, as I've discussed, and associated fines. Under federal criminal law, there is a criminal code offense of trespass, but it applies in a very limited set of circumstances, none of which were applicable to what happened on the Stanley farm that day. Police responses to trespass are limited with respect to their use of force, generally prohibiting the use of lethal force in response to property crime. However, the criminal code also provides for the use of force, including weapons, by laypersons in defending entry into their property. And this creates a strange inconsistency. The same actions taken by an individual deemed a trespasser can be treated with consequences ranging from civil damages to a modest fine of up to $2,000, where trespass is proven by the Crown and enforced by the police, to the application of force, including the use of firearms by a private citizen prior to arrest, prior to the involvement of police or the criminal justice system, and any form of trial. Under Saskatchewan's trespass law, enacted in just 2009, land has been required to be enclosed, either by fencing or a natural boundary, or by oral or written notice, such as a sign. Without notice or enclosure, entry onto private property is not trespass until a request to leave has been made by the occupier and the person entering the premises has failed to leave. The owner must give time to comply. The Stanley farm was not enclosed with a fence. The youth were not asked to leave the farm before the shooting began, and muddy shoe prints in a pair of shoes found in the long driveway suggest that some of them were in fact trying to leave. The Act also requires police be notified to enforce the arrest provisions or penalties. The police were not called until after the gunshots were fired and Colton was dead. Had they been called, the police could have imposed for trespass a maximum fine of $2,000. They themselves would not have been justified in using lethal force to respond to the circumstances. The defense of property has long been recognized in criminal law, when a landowner has been justified in using force to remove a trespasser. But there are limits, just as there are under the provincial quasi-criminal regime. An alleged trespasser must be given time to comply, certainly before force is applied. A defendant must show that force could not have been less violent, and the resulting harm must be proportionate to the injury or harm it is intended to prevent. Gerald Stanley did not raise the defense of property, even though, as we've heard, language like home invasion, trespass, and intruder were part of the defense story at trial. Had the defense been raised, it would have been necessary to justify why a gun was involved and why that was necessary in defending the farm, which would have been quite difficult. Open questions remain as to why the defense of property was not raised, why the Crown conceded that the firing of the warning shots were reasonable in the circumstances. Now these questions will never be answered because there has been no appeal. But even without raising the defense, the narrative of trespass and the right to defend private property were a crucial underpinning to the narrative used by the defense. Indeed, it was picked up by the media right away, even before the trial, and it continues to this day, feeding the current reforms of trespass law as a response to rural crime. If you follow the logic of the defense in the case, Colton Bushi and his friends trespassed onto private land. Gerald Stanley was rightfully upset about their incursion and responded by seeking a weapon, firing it multiple times, and ultimately killing one of the youth at close range. Therefore, while the defense of property was not raised to justify Stanley's actions, the death was a direct result of A, the status of the youth as trespassers, and the right of Stanley to respond to trespass with a firearm, including potentially causing grievous harm or death. We should all be concerned that this narrative was allowed to dominate the trial without getting expressly addressed or questioned through a defense of property analysis. It creates an inconsistency with respect to the use of force under Canadian law. The notion of trespass looms large in rural areas, not just in Saskatchewan, but across Canada. Allegations of the rise of rural crime inform calls for private properties to have the right to defend with firearms their property against intruders. The amendments to the Trespass to Property Act strengthen property owners' rights and removing the onus to post signage and on private land. The response is explicitly linked to this construction of something called rural crime as a specific and growing problem centered on property crime. The changes are intended to make it easier to deem someone a trespasser, ostensibly to protect against this specific form of crime. However, in the shadow of the Stanley trial, major questions arise about the consequences of such labeling. Recall the logic of the defense, which leads to the rightful use of firearms, even lethal force, in the face of trespass and property crime, prior to the involvement of the police and the justice system. We have to ask ourselves if this shift towards justified violence in the name of property is consistent with Canadian law and with the relationships on treaty land in particular. The place-based relations of Treaty 6 and the Indigenous laws applicable to this land may tell us otherwise. Others can do much better justice to what those Indigenous laws and the meaning of the treaty might be. But I think it's important that we call into question the interpretation of the treaty as having cede and surrender, and instead think of it as a sharing of the land. And our understanding of the defense of property should be informed by this understanding. This context is almost uniformly absent from criminal proceedings and was absent in the Stanley trial, where ideas of property were significant factors. The ongoing violation of the law of property set out in the treaty informs the construction of rural crime as the source of tension in Indigenous and non-Indigenous relations today. The rhetoric of rising rural crime here and elsewhere in Canada has heightened since the trial, often importing notions of the invasion of an otherwise peaceful agrarian countryside by violent forces, the fear of Indigenous youth in particular we've just heard about. Such narratives can be used by legal actors to shape the application of law in particular ways, courts endorsing or upholding particular representations of the rural, even absent evidence to that effect. And distinctions between the rural and the urban can lead to differing rules or standards being applied. This particularly is of concern with respect to property rights, with rural property deemed to be of greater importance to the residents of rural areas, and rural residents as more autonomous and independent from the state. This underpins a narrative in which a white farmer is constructed as an innocent victim, and the Indigenous youth killed by that white farmer is a violent intruder. A particular form of rural resident being able to reap the rewards of the privacy protections and self-help remedies being proposed in the trespass legislation. The reality of many other rural lives, particularly Indigenous peoples or even migrant workers, are obscured by this particular vision of what rural life is. In the Stanley trial and the legal responses to it, that version of rurality created a situation in which Stanley belonged on the land and Colton Bushi and his friends did not. In fact, Stanley's property and his things belonged and mattered more than they did. Criminologists have pointed out that the rural idyll actually belies the facilitation of certain forms of crime, such as gender-based violence, and particularly, I would argue, the violence perpetrated on the bodies of murdered and missing Indigenous women and girls. If we examine the actual statistics on crime, a very different picture emerges than the one that we see in the media. The rural crime rate in Saskatchewan is indeed higher than the urban crime rate. However, violent firearms offenses have increased by 47% in rural areas of Saskatchewan, and in 2016, Saskatchewan had the highest rate of rural firearms in the country. Saskatchewan rural firearms crime. Saskatchewan also reported the highest rates of family violence, with a 3% increase from 2015 to 16. And while it's not broken down by province, Statistics Canada reported that women living in areas outside large population centers face particularly high rates of family violence. Statistics Canada also reports the most serious forms of property-related crime have been decreasing, particularly motor vehicle theft. The caucus report about the Trespass Act notes widespread concern about youth crime, and yet the statistics show that youth crime is also decreasing. In 2017, seeing a decrease of 8% in Saskatchewan in particular. So as we see the notion of trespass imported into criminal law, we need to think about how judges can and legal actors can be attuned to how notions of rural crime and fear of Indigenous people intersect with harmful stereotypes and labels like trespassers or intruders to shape outcomes absent evidence and a legal basis. In Canadian legal doctrine, Canadian courts have long recognized the potential for systemic racial prejudice in the justice system, and implicit narratives about property and trespass have the potential to compound that systemic racism and introduce discriminatory beliefs into the fact-finding process. Actors in the justice system must address this directly, and in the Stanley trial we saw a generic charge to the jury that failed to do this work and instruct the jury about the harm that could come from the combination of labels that had really no place where the defense of accident was relied upon and the defense of property was not, how they could combine with the systemic racism in the justice system to influence the outcome. I'll stop there because I think we probably have run out of time.